Welcome, everyone. Thank you for joining today's webinar. My name is Lori Berman, and I am Vice President of Membership and Development for the Small Business Association of Michigan. I want to especially thank today our two co-presenters from Warner Norcross Judd. Warner Norcross Judd is a great partner of the Small Business Association of Michigan. They participate with our Leadership Council, and they help us with some of the member benefits when it comes to compliance. The folks today have stepped up to help bring you this information, and we are very appreciative that you're doing that. Before we introduce the presenters today, I wanted to let you know this is a part of a series that SBM is doing. We do on a regular basis. We offer webinars for our constituency. There is another one tomorrow on HR issues and another one on Friday navigating financial options during this crisis. So I encourage you to take a look at those as well. I wanted to remind you too that as we give you this very substantive information, make sure you don't take it as exact legal advice. Our role here today is to lay out the issues that you're facing as a small business owner right now and help direct you to those answers today. So stay tuned, there's a lot to cover. Let me introduce our speakers today. Our first speaker is Troy Cummings. Troy is executive partner at Warner Norcross Judd. He is chair of the firm's government affairs group and serves as the executive partner of the Lansing office. Troy has over 20 years of experience working on government policy in Michigan, other states, Washington, D.C., and around the world. Welcome, Troy. Our other presenter is Dean Pacific, who's a partner at Warner Norcross Judd. Dean is a litigator who defends employers. In court, he represents employers in cases of alleged discrimination, harassment, retaliation, wrongful discharge, and the full range of statutory employment claims. Welcome, Troy and Dean. Again, thank you for being here. We will be taking questions today. I do ask the audience that please only send us questions that are related to today's topics. If you have topics that are questions that are unrelated, such as loan help, etc., please send those directly to sbam@sbam.org. That's sbam@sbam.org. Those are for questions that aren't related to today's topics. But if you do send us questions on topics today, we will address those as best we can during today's presentation. So Troy, I'm going to turn it over to you. Take it away.
All right, thanks, Lori. I'm going to start out talking about critical infrastructures under the Stay Home, Stay Safe order. And a lot of material to cover, so I'm going to jump right in. First, just a little bit of background. As you all know, the executive order became effective midnight on March 23. This really came about as kind of following Ohio. Ohio did their stay home order Sunday, announced it on Sunday afternoon. And so Michigan kind of put it together very quickly, became effective. Some routes that they could have followed is following states like California, Illinois, and Ohio. If any of you on the call have facilities in those other states, you know, those were pretty good examples. But in Michigan, Governor Whitmer chose to be quite a bit more restrictive in her order than those other states. And then the other thing, just a matter of background, it's effective through April 13. But I think no one will be surprised to know that I anticipate it likely to be extended beyond that date. I think we will learn more next week on that. So jumping into the order itself, I wanted to first start out by this quote in the order. It says, "This order must be construed broadly to prohibit in-person work that is not necessary to sustain or protect life." You know, that's right up front in the order. And so as we're talking through all of this, I think it's good to keep in mind kind of where at least where the governor is at with how she looks at this order. I think she really views it as wants it to be pretty restrictive and folks to stay home. And that's always a lens she's looking at this through. Jumping into the operative provision. So what we're going to really talk about is critical infrastructure workers. And And the starting point there is the requirement that no business may require workers to leave home except to the extent that those workers are necessary to two things: sustain or protect life, or conduct minimum basic operations. So those two concepts, minimum basic operations is different than critical infrastructure. It's basically those employees necessary to keep the kind of very minimum, keeping your operation going. But the definition is very restrictive. So I put the definition there, and it's pretty limiting. I mean, there's some ways that you can interpret that a little bit broader and whatnot, but I mean, it's a pretty restrictive list. And then what I want to talk a lot more about today is critical infrastructure workers. And so that phrase, necessary to sustain or protect life, that's a very broad term. The governor has said that publicly and whatnot. But what the order does, it kind of takes that phrase and it defines it. So necessary to sustain or protect life really is defined as critical infrastructure workers as defined under a couple sections in the EO. And so going into those sections, you know, what's a critical infrastructure worker under sections 8 and 9 of the order? I'm going to start with the ones that you probably have the most, probably been confronted with the most. The starting point here is really adopting the federal guidance. What the order does is it looks at the CISA guidance that's dated March 19, 2020. I put the quote in there. It's those workers described by the director of CISA in his guidance of March 19, 2020 on the COVID-19 response. Essentially what that guidance memo does, I listed the various critical infrastructure sectors there, and within each of those sectors, healthcare, public health, energy, public works, you know, all of them, critical manufacturing, it lists very specific types of workers within those sectors that are covered. A lot of times it's pretty black and white, but we'll talk about gray areas in a little bit, but some of it does create some questions about whether or not your worker, you know, might fit that. But that's kind of the first step is looking at that CISA guidance. Then the other one that I wanted to talk about, because, you know, at least with our clients, we're seeing this probably more than any other type of critical infrastructure worker, is what I kind of call the designated supplier. So there's a couple provisions in the order where maybe your business specifically might be not deemed critical infrastructure, but let's say one of your customers that you supply or you provide a service to is a critical infrastructure employer. What the order allows is for your customer to basically, you know, most of the times it's done through a letter. They will designate you through a letter saying, hey, we're critical infrastructure. You're necessary for us to do our critical infrastructure work, and therefore you need to stay operational. And I think that is probably the most, we've seen that the most, at least with our clients. But a couple of things I just want to mention. Only to the extent those workers are necessary. So that's the wording right out of the order. It's not like, oh, we got this letter so we can go 100% back into operation. It's only to the extent necessary to service or supply the critical infrastructure customer. And they had this kind of scary language in their abuse of discretion and subject to sanctions to the full extent of law. That really doesn't mean anything. It just basically means if you don't comply, you know, you can get fined, or, you know, we'll talk about enforcement in a bit. But I think that's there to kind of just make sure people are really not trying to push the envelope too far. The next one is, it kind of goes down the chain. So let's say you have a customer that's critical infrastructure. You're a tier 1 supplier. You get the letter. Let's say you have a supplier that is necessary for you to service your customer. You can send them a letter saying, hey, down the line, you need to stay in operation for me. And it kind of works the same way, but the order allows down chain supplier service there. And then I have a slide here. I'm not going to go into these, but then there's some very specific types of workers that are included as critical infrastructure in addition to CISA guidance and the supplier exceptions. and that I list them there. Now going into, what, if we need guidance on this, what's out there. So I'll start with executive order FAQs. So the governor's office has decided as of right now not to issue any new order or revised order. Instead, they're providing guidance through FAQs. There's a website, I put it there. There's a link onto the FAQs and a lot of other information, but they're updating it. Sometimes daily, they'll add some FAQs. This table that I've included is just a snapshot of as of last night. These are the things, the various issue areas that the governor's office has issued FAQs. And you'll see, this is critical infrastructure. Those things clearly, they've said it's critical infrastructure. Then there's a few things, issue areas where it's not critical infrastructure, and then others where it can be. So car dealerships, they can't sell cars, but their car maintenance department can stay open, things like that, where it's kind of limited. So that is something that you can keep apprised of on a daily basis, and you get guidance that way. Other guidance, it gets kind of confusing, but some state departments and agencies on their websites, they've provided independently some guidance in addition to the FAQs. And so, to the extent, you have some issue areas that, I always check the departments too and agencies' websites for further guidance. And then a lot of you have heard the governor's making public statements out there. And I'm always careful with that because I think it's guidance with her statements in that it gives you a feeling of where her thought process is on how it should be implemented and whatnot, but it doesn't change the order itself. So if she uses different words, that doesn't change the EO, but it definitely gives you a sense of where her mind is at and when you're looking at how to comply. But there's been some confusion with language she's used, and does that change the EO? It doesn't. And then I want to jump into gray areas real quick. So sometimes it's black and white, but what we found with a lot of our clients, and I'm sure some of you have questions today on this, there's gray areas. So the CISA guidance memo we talked about, do you fit within some of those categories? It can be black and white, can be gray. What about other CISA guidance? So the CISA itself, outside of the guidance memo, has on their online, has some additional guidance. How much can you use that? What about an updated CISA guidance memo? So they're now, since the 19th, they're on their second iteration of that memo. Well, what do we do with those changes? That creates some gray areas. The letters, so when you receive a letter from a customer saying they're critical infrastructure, looking at what that letter says, what it needs to say, that can be gray, definitely take some further analysis. And then employee relationships. If you are going to come back into some percentage of operation, maybe less than 100% or even up to 100%, how does that work with your employees? How do you talk with them? How do you choose which employees? All of that kind of thing. That can create some gray areas. Related requirements, just want to talk real quick. Just because you might have a critical infrastructure worker doesn't mean that you just could ignore the order. There's other requirements that you have to follow. You have to send, there's 3 types of letters or write in writing that designations that you have to make. If you have minimum basic operation employees, you need to inform them in writing by yesterday, actually, under the order. If you have critical infrastructure workers in writing, you need to inform them by yesterday. And if you have a supplier underneath you, or if you have a customer above you in that supplier service provider context, you have to put that in writing also. And then there's COVID-19 protocols. So when you do have employees in, there's certain restrictions that you need to continue to make sure that you're complying with, like social distancing protocols for if you have an employee that becomes sick, shows symptoms. What if they're diagnosed with COVID-19? Those types of things. for our clients, we've actually worked for put something in writing for those protocols for each of our clients. Definitely something that you want to work with your legal counsel on all of this to make sure that it fits your situation specifically. And then the last before I open it up for Q&A here is I just want to talk about enforcement a little bit. Technically under the order, the violation is a misdemeanor up to $500 fine or 90 days in jail. I am not aware of that ever happening anywhere in the state. Law enforcement and the AG have really taken more of an approach of having a conversation and asking folks if there's issues to shut down rather than charge anybody. So technically it's a misdemeanor, but I would be shocked unless it's a very egregious situation that ever happens. The AG on her website has provided some guidance to law enforcement, and she has actually taken action as of last night. She did send a letter to Joanne Fabrics asking them to shut down. I think that's the first time she's actually done something like that. But again, not charging anybody, just asking them to shut down. And then we've heard a lot from our clients, and many of you might have already been confronted with this, where local law enforcement will call you or show up. And that's happened a lot. And really what they're doing is they're responding to complaints that they've received. And for the most part, we haven't had any problems there. It's been very smooth when we have been involved, the lawyers, explaining the situation, and generally that's been okay. Definitely with all of this enforcement though, you need to include lawyers, your attorneys on this, especially with any law enforcement, with those direct conversations, just to make sure you don't cause any issues for yourself. And that's about as fast as I could possibly go through all of that material. There's a lot more, but I definitely wanted to keep a lot of time for Q&A. So
Great.
I think we can open it up for that.
Yep, thank you, Troy. We do have quite a few questions here. The first one I'll start with is this person identified their critical suppliers, but left one off. Letters were supposed to be dated yesterday. Can they still do that today? What do you recommend?
Oh yeah. I mean, you might have missed a deadline, but definitely do it, because there could be situations, of course, where maybe someone doesn't they don't become a supplier until after 3/31, right? So that's definitely a situation, and I would just send the letter now.
Okay, there's been a couple different iterations of the CISA memos that you mentioned. Which one should people work off?
Yeah, so that's one of the gray areas, and I want to be careful here with giving kind of specific legal advice, but I can tell you that that really creates a question, under Michigan law. I would definitely talk to your lawyer about it. The issue really is when something's incorporated very specifically, there's arguments that that's kind of frozen in time, and it doesn't incorporate any changes, right? But it's gray, just with, a lot of people have I will tell you that even, I've just seen people take different stance on that, but there's definitely a risk involved. So I don't think that the governor's office, as of right now, is going to update the actual EO to incorporate any revised versions of that memo. I don't think that's going to happen, at least as of right now. So I think we're stuck with kind of this issue. And if you're in a situation where maybe the 319 memo specifically didn't cover you, but maybe I think it's maybe 323 and the 328 versions do, I think you need to talk to your lawyer, talk through the issues, and try to get to a point where you're comfortable. I mean, you can get a bit, I don't want to say creative, but there's flexibility here, and you just have to be comfortable with how you move forward, and you definitely have to involve a lawyer.
Thank you. The next one is, our company has been identified as a critical supplier. They have employees there working. The question is, when there's downtime and there's a job from someone maybe that isn't the critical supplier, can people keep working on other jobs, or can they only work on the customer jobs that they're identified as a critical supplier?
Yeah, so that goes to my point where I wanted to put that quote, only to the extent necessary. So technically under the order, if you're up and running under the order, it's only as necessary to service the critical infrastructure work.
Okay.
Outside of that, you need to, talk to your lawyer, because of course there's some minimum basic operation things obviously there too, but that's what the order says.
Okay, thank you. There's quite a few questions around what is a construction worker, specifically trades. I don't know if those are things you can answer for us, if they're too distinct. Someone else asked, what does construction mean? Does home renovations qualify? Can I mow a lawn? Those type of things. What's your guidance in trying to figure those very specific questions out?
Yeah, so I would direct you right to the Q&As, because there's a Q&A on landscaping, kind of lawn care. That's one of those that it depends if it's necessary to protect, the safety of the home, something like that, to do some type of work. You could, that's what the Q&A would say, you could do it. But just generally a mow service, come and mow your lawn, that would not be included. Or not be deemed critical. But read the Q&A, it kind of walks through that. With construction, it's the same kind of thing. I think they've said home construction is kind of shut down. There's some construction that can continue as critical, but again, it's going to kind of what's necessary to upkeep the house, safety, those kind of things. But there's a Q&A directly on point on that. But I will tell you, that's one of the gray areas, and so you really got to look through that and then talk very specifically about what type of work you're talking about. Work with your lawyer. That's what we've done with our clients that have had questions around construction. What types of things can we continue? But the good thing is that there's further guidance on that in the Q&A.
Great. And then this one here was asking, were our employee letters, we talked about that a couple minutes ago, are they required to issue letters to employees if they're requiring them to continue to work? The answer is yes. Any other guidance on that?
Yeah, so any of your critical infrastructure workers, let's say you have 100 employees and you've deemed 30 of them are necessary to come back, and you determine which 30, the order, that's when those are the requirements that I mentioned about putting it in writing. By yesterday, actually, was the timing on it. But yeah, you need to do that. And I guess the further thing that I would say is, just, work with your attorney, or just make sure that it's complying with the statute. That's what we do with our clients. We kind of, look at each client and make sure that the letter's fitting their situation. But it's not as easy as just like sending the same letter to everybody. Each of our clients' letter is a little bit different.
Right. Okay, thank you. Well, I think we've gotten through most of the ones from this part. I just want to remind folks that you will find some of the FAQ information that Troy's mentioned that the state had out there about this. It is also on the SBAM site in the COVID resources. There's several questions here that I'm looking at right now that do relate to the Family First Corona Response Act. So it's a good time to kind of segue to Dean. And Dean, why don't you go through your information, then we'll answer some of these questions I have right now. All right, thanks.
Thank you very much. Yeah, so we're going to shift here a little bit and talk about some new employee rights and employer obligations that are part of a federal law that was just mentioned, the Families First Coronavirus Response Act that was passed just and signed by the president just 2 weeks ago. So this is all new law, although parts of it are sort of interposed on top of the existing Family and Medical Leave Act. That may make some parts of it easier to understand for some folks if you have a business with more than 50 employees and have already been covered by the FMLA, although many of the rules are different and specific, and we'll talk about that. However, what the law also did is it made at least this narrow portion of the FMLA, this expansion, applicable to employers with less than 50 employees, and in fact, all employers with less than 500 employees. So there's some folks here that are going to be covered by both this Paid Sick Leave Act as well as the expanded FMLA, who aren't used to dealing with FMLA because normally you'd be exempted. So I want to walk through and make sure everybody understands what these new laws require, and also talk about some of the things you need to do to comply with both your employees' rights and your obligations as an employer under these where they apply. So as a starting point, I'm going to talk first about the Paid Sick Leave Act. This FFCRA, you've heard it referred to, included a number of things that aren't pertinent to this discussion, like some expansion of food benefits and things like that, SNAP benefits. But from the employment point of view, there's really two important new benefits or rights. And the first is the Paid Sick Leave benefit in the Paid Sick Leave Act. The second is an emergency expansion of the Family and Medical Leave Act. So again, starting with the Paid Sick Leave Act, the first question then is which employers does this cover? And what the statute says is it applies to all employers with under 500 employees. And that means you count up all your employees, and that includes both full and part-time workers, and includes, regardless of which site they're at, anywhere in the United States, any of the 50 states, District of Columbia, the US territories. And you also count employees who are on leave. You count day laborers or temp workers if there's an ongoing relationship with those folks, regardless of whose payroll they're on. And if you are under 500, then this law applies to you. And if you're over 500, it doesn't. If you are part of an organization where you have interrelated businesses, there's something called the Integrated Employer Test that applies to regular FMLA, and some of you may be familiar with that. Troy, I think you've got control of the slides now. If you can click ahead to the next one. If this is a question for you, if you've got interrelated businesses, some related by common ownership or parent subsidiary or other type relationships like that, you need to understand that you may be required to or be able to count those together to decide whether you meet that 500 threshold. And that normally comes down to a question of how interrelated the companies are. Do they have common ownership? Do they have common management, so that you've got a sort of cross-pollination of top officers and directors and executives and things like that? Are the companies interrelated in terms of their operations? And especially, are they interrelated or centralized with respect to their labor relations? So if you've got three related companies, but there's one human resources department that handles all of the employee relations matters, if you've got one handbook that covers everyone, they're all part of the same employee benefits plan, you may well be an integrated employer. And then that requires, again, some particularized analysis. So if that's an issue that may apply to your business, that's something you're going to want to talk to counsel about for your particularized situation. Next slide here, Troy. One provision of this that'll probably be of interest to many of the folks listening is what's been referred to as sort of the small business exemption here. Really, it's a potential exemption. It's not automatic. So I want to talk about that for a minute. What this Paid Sick Leave Act said was that the Secretary of Labor had authority to issue regulations to exempt employers with less than 50 employees if complying with these obligations would jeopardize the viability of the business as a going concern. Now, again, keep in mind here, this is not a blanket exemption for everybody with less than 50 employees, as you would have in the FMLA, the regular FMLA. What they've said is that the Secretary may exempt those employers. And the Department of Labor now just came out with some guidance the other day. This isn't still the final regulation that's referred to in the statute, so this could still change. But what the Department of Labor is saying right now in the questions and answers that they're publishing on their website is that a small business may claim this exemption if they have an authorized officer of the business make one of three determinations. And the next slide talks about what those three are. And Again, keep in mind, these are ors in between these. So if any one of these three applies, you may be eligible for the small business exemption. The first one is basically sort of a bottom line test. So if the cost that you have to pay for this benefit would exceed your available financial revenues, then you may be eligible for this. If expenses and financial obligations exceed available business revenues, such that it would cause the business to cease to operate at a minimal capacity, then you may be able to seek this exemption. Second, they say, and this focuses more, as does the third one, on sort of who's asking for the leave. If the absence of the employer or employees seeking leave would put a substantial risk on the financial health of the business or the operational capabilities of the business, because those folks have some specialized skills or knowledge or responsibilities, then you may be able to seek this exemption. And third, again, related or more similar to that second one, focusing on the employees involved, if you find that you don't have sufficient workers available who are ready, willing, qualified, and available to do the work needed that the employee or employees who are seeking leave would ask, such that you wouldn't be able to operate at a minimal capacity, then that may also qualify you for this. And again, any one of these three can be sufficient. And what the Department of Labor is telling you now is that you can claim that exemption, you can seek that exemption if an authorized officer of the company makes that determination. The obvious question that raises probably is who's the authorized officer that can do that. I expect we'll get some more guidance from the Department of Labor on that, but as yet, they haven't defined that term. I would say use a common sense approach at this point. If you're talking about this first category that's focused on sort of bottom line financial calculations, the CFO of the company or controller might be the appropriate person to do that. On the latter two, that focuses on sort of the ability of the business to operate, without the employees involved because of operational concerns. It may be a COO, a director of operations, a human resources administrator, just depending on the way in which your workplace is structured. But again, I expect we'll get more guidance from the department on that going forward. Troy, if you can advance to the next one, I want to talk about, what exactly is required if you are a covered employer then. And what the Paid Sick Leave Act says is that employers are required to provide paid sick time to all employees. That includes new hires, that includes full or part-time folks who are unable to work for 6 specified reasons that are related to COVID-19. So this part of the statute applies to every employee. We'll talk about the FMLA expansion later, and that has some other requirements. They have to have been there 30 days, and we'll walk through that when we get to the FMLA part. But with respect to the Paid Sick Leave Act, where it applies, it covers every employee, including people who've only worked 1 day, including part-time employees. Now, the important thing to focus on is what are the specified reasons for paid sick leave. There's 6 of those that are listed in the statute, and we get to those in the next slides. And these are all things that are related to COVID-19. So just because somebody's sick, if somebody broke their arm, has some other reason under your normal sick leave policy, they might need time off, that's not covered by paid sick leave. What is covered, and Troy, if you can just flip to the next slide here, we start going through those, is really 6 specified reasons. And I'm going to walk through those with you right now quickly. You'll note, if you see here, there's a little bit of a pattern in that the first 3 all relate to the situation of the employee themselves, their health condition or their personal situation. The 4th and 5th relate to the need of folks to care for others, and the 6th is sort of a catch-all. So let's walk through those for a minute. An employee is entitled to this emergency paid sick leave under the statute if first they are subject to a federal, state, or local quarantine or isolation order related to COVID-19. They're also entitled to it if they're advised by their healthcare provider to self-quarantine for COVID-19 related reasons. And also they'd be entitled to it if they're experiencing symptoms of COVID-19 and they're in the process of seeking a medical diagnosis. So again, those first 3 all relate to the condition or situation of the employee themselves. Then if we look at the next screen, the next slide, 4 and 5 talk about the need to care for others. The 4th category is someone who's caring for an individual. Your employee is caring for someone who fits into one of those first 2 categories we talked about. So they're either caring for someone who's subject to a quarantine or isolation order, or they're caring for someone who's been advised by their healthcare provider to self-quarantine due to COVID-19 related concerns. The fifth category that would require under this paid sick leave is if they're caring for their son or daughter, not any child, but their son or daughter, and that's defined expansively. It includes stepchildren and things like that, but it doesn't include nieces and nephews and grandchildren, the neighbor's kids, or anything like that. If they're caring for a son or daughter of the employee because that child's school or place of care is closed, or their child care provider is unavailable. And obviously, right now, virtually all of the schools are closed, daycare centers are closed. Individuals who may have provided, babysitting or daycare are under the governor's executive order, not able to care. So this covers a lot of folks now. And those folks are also entitled to this paid sick leave benefit. Finally, there is a catch-all at the end, and that one, as you can see, simply indicates anyone experiencing any other substantially similar conditions as determined later by the relevant departments here. We haven't got any further guidance on that, but just be aware that there may be other similar categories identified later by the Secretary of Health and Human Services or through the Department of Labor or Treasury that they're supposed to consult with. So the big question this raises, and it's the one that we get asked the most right now for the last week or so, is Governor Whitmer's stay-at-home order a quarantine or isolation order that triggers the paid sick leave benefit? And that was an open question that wasn't answered either in the statute, the initial guidance from the Department of Labor, or the governor's order. Late last week, the Department of Labor did issue guidance on this and indicated, while they didn't directly answer the question, they did indicate in the way that they answered more general questions that it is not. So the governor's stay-at-home order under the Department of Labor guidance is not a quarantine or isolation order that would entitle an employee to paid sick leave under this statute. And what the Department of Labor told employees there is that if your work site is closed, you will not get paid sick leave or expanded family and medical leave, but you may be eligible for unemployment. And they said, this is true whether your employer closes the work site for lack of business or because it was required to close pursuant to a federal, state, or local directive. So based on that guidance, it appears they're taking the position that those first three categories are applying much more narrowly to someone who themselves is sick or themselves is experiencing those symptoms or is subject to a more personalized order to quarantine or isolate, as opposed to the sort of general order that the governor has given to all of us at this time. And Troy, if you can flip ahead, I want to talk a little bit then about the benefits and what they get if they are covered. What the statute says is that full-time employees are eligible for 80 hours of paid leave, and part-time employees are entitled to leave in an amount equal to the amount of number of hours they normally work in a 2-week period. And the statute didn't initially define full or part-time, although they did come back in the online guidance and indicate that full-time for these purposes means 40 hours or more per week. So some of you may have employees that you classify as full-time for employee benefits or other purposes with, say, 37.5 hours a week or something like that. And that's fine. That can still apply to your other operations. But with respect to this act, they're saying that full-time means 40 hours or more per week. Part-time means anything less than that. There are some caps on these benefits. If we move forward, you'll see that employees who are off for one of those first three approved reasons related to a quarantine or isolation of themselves or their own health condition, they are entitled to get full pay. And Troy, if you can flip ahead, there's some information about this on the next slide. They're entitled to receive full pay, but there's a cap on that, and that cap is $511 per day, or a total of $5,111 total. In other words, 2 weeks or 10 working days of that pay. For the employees who are home for the fourth and fifth category of reasons, where they're taking care of someone else, they're entitled to 2/3 of their pay. And that has a lower cap. That's capped at $200 per day or $2,000 total. Again, kind of aligning with 10 days. And these amounts are all important because there's a corresponding tax credit that goes with these that's supposed to help reimburse the employer for providing these benefits where it applies. And so you're always able, if you would like, to pay employees as an employee relations matter or out of generosity or whatever your motivations, you can pay them more than that. But the amounts that are required strictly by the statute are the only amounts you'll be able to receive the tax credit for. Finally, it's important to note this paid sick leave. Some of you may have policies that allows people to carry sick leave over into future years or to be paid out at termination. This paid sick leave under the statute, it expressly says, does not need to be paid out at termination. So it's use it or lose it. If they leave the company for any reason before the end of the year and before they've used up all their paid sick leave potential, they don't get to take it with them or receive payment on the way out the door. And this does not need to be carried over into next year. This statute has a sunset provision. It ends unless Congress takes some other action to extend it on December 31st of this year. And so this benefit doesn't carry over into next year. I want to shift now and talk a little bit about the expanded FMLA benefit that's provided in the same statute. The Emergency Family and Medical Leave Expansion Act, again, applies to companies with fewer than 500 employees. Same tests apply. We talked about the integrated employer test that could potentially apply if you have related organizations, the small business exemption that's potentially available for certain employers with less than 50 employees. Those standards are the same as we discussed with respect to the Paid Sick Leave Act. And so I won't repeat that discussion here. Just understand that it's the same tests and the same standards. The Emergency Family Medical Leave Expansion Act, then, in terms of which employees it applies to, if we want to move ahead, Troy, this one, as I had sort of previewed earlier, doesn't apply to every employee. It does still apply to both full or part-time people, but it applies to employees who have been employed for 30 or more calendar days by the employer and also have a qualifying need, which we'll get to in a moment. Some of you who are normally covered by the FMLA may be used to dealing with the normal test, which is an employee has to be there for 12 months and have worked 1,250 hours. Only with respect to this expanded leave, that test doesn't apply. That test would still apply if you have employees who come in and seek normal FMLA leave because they need to have ankle surgery later in the year when the hospitals are open back up again for that sort of thing. But with respect to this leave covered by the Act, this other definition applies. 30 or more calendar days is all that's required. You may have also heard about the CARES Act that was passed by Congress and signed by the President at the end of last week. There was one update to this emergency FMLA embedded in that, and that is they put in a provision that said that if there are employees who were laid off during the month of March, but they had worked for 30 of the last 60 days for you before that and are subsequently rehired, they're also entitled to this benefit. And that was really intended to pick up folks who, by the time the law was passed, were already laid off due to circumstances related to COVID and couldn't possibly have worked 30 days if they were new hires. So they brought them within the scope of that if they meet those three requirements there. In terms of a qualifying need under the expanded FMLA, that's covered on the next slide. This is a much narrower benefit. We talked about 6 different reasons why you might be able to get the 2 weeks of emergency paid sick leave if you're covered. Here, there's just essentially one reason. It's the one, if you recall, that was also number 5 on the list for paid sick leave. So this is intended to be covered by both paid sick leave and then also by this emergency FMLA, the first 2 weeks under paid sick leave, and then beyond that up to 12 weeks under the FMLA. And this applies only to folks who have a need related to caring for a child whose school is closed, whose daycare provider is closed, or whose childcare provider is otherwise unavailable due to COVID. A lot of you may have seen media coverage before this act was passed that provided for a much more extensive expanded FMLA benefit. That was changed. The bill that passed the House of Representatives actually had a more expansive extension of the FMLA. That got changed in the Senate before the President signed it. And so the emergency FMLA expansion benefit is much narrower than the paid sick leave benefit and only applies to these sort of childcare related reasons that are listed here. What the law says then is employees can take the first 10 days of leave as unpaid leave. And again, what's really intended here is that these two things work together. So they can use the paid sick leave to cover those first 2 weeks. And then after that, they can use the FMLA expansion. Employees can elect to use other accrued leave if they want to, if they have vacation, PTO, sick pay, whatever sort of paid leave you normally provide to your employees. They can elect to use that as opposed to, for example, using the paid sick leave the first 2 weeks. Maybe they want to save their leave for later because they know something we don't know. That's probably going to be kind of unusual, but they are allowed to make that election. What's clear, though, the other side of that coin is employers aren't allowed to require them to use that before using the statutory leave. So you can't tell employees you have to use up your PTO, you have to use up your paid vacation or other paid sick leave that's covered by other employer policies before they can use these benefits. Again, if for whatever reason personal to them, they want to do that, they can elect to do that, but you're not allowed to require or coerce employees to do that. The benefit here then, in terms of the pay, is that you have to pay folks at least 2/3 of their regular rate of pay. And again, the statute says at least. I will clarify again, you're only going to get the tax credit for the 2/3. So if you choose to pay more as an employee relations matter or something like that, you're certainly allowed to do that, but they're only going to allow the payroll tax credit for the 2/3 that's required. You have to pay 2/3 of the employee's regular rate of pay multiplied by the number of hours that they would normally have otherwise been scheduled to work. And this credit is the tax credit, and the pay here is capped at $200 per day or $10,000 total. I want to talk a little bit about job restoration. Folks here who are listening who are covered by the regular FMLA are probably familiar with the fact that under regular FMLA, employees generally have a right to job restoration at the completion of their leave, which just means that they're allowed to come back to their old job or to a substantially equivalent job if that job is no longer available. There is a potential exemption written into this expanded FMLA. And again, this applies to this expanded FMLA only and not to regular FMLA if you're covered by that. But if you give someone this expanded FMLA leave and you have less than 25 employees, at the end of their leave, if the position that they held no longer exists due to circumstances related to COVID-19, so for example, you've had to downsize, reduce your workforce because of the economic conditions created by this, then you don't have to bring them back so long as you make some reasonable effort to find them an equivalent position. You don't have to create a job or make work to them, but you make a reasonable effort to sort of look at your workforce, any available positions you might have, and make those available if there's an equivalent position that they're qualified for. Again, that's what you would normally do if you're covered by regular FMLA. The only thing that's different here is that if those efforts fail, you do have an affirmative obligation over the next 12 months to just try to contact them if an equivalent position becomes available. So that's one extra obligation that they're applying to the restoration situation here. One of the questions that comes up, again, folks that are used to regular FMLA may be used to the issues related to intermittent use of FMLA leave, which means instead of taking 12 weeks or some period of weeks altogether, folks may take a day here, a day there, even sometimes parts of a day intermittently. And this answer applies both to the paid sick leave and to this expanded FMLA. What the Department of Labor has said is that if you're a teleworker, you may be able to use these intermittently, but only if the employer agrees. So you have to agree to this. Folks can't demand to use this leave intermittently. I think this is a recognition by the Department of Labor of the difficulties that businesses are struggling under right now, trying to keep operations going in these difficult times. And so folks who are teleworkers, it's at least possible that they could take leave intermittently, meaning, for example, you and they agree that they work Monday, Wednesday, and Friday and take leave on Tuesday and Thursday, for example, if they're caring for a kid, and that's what works out with them and their spouse. But that's if it's telework. If it's in-person work, then you can still do it if it's for the childcare reasons, but not if it's for any of those other reasons. So if the person is sick, if it's any of those individual reasons for paid sick leave, you can't use intermittent leave. And the Department of Labor explained that the reason for that is because the whole purpose of this and everything else that's going on is to prevent the spread of the virus. And so we can't have people who are under a quarantine order, for example, coming to work one day and not the next day. That's just not consistent with how we're handling efforts to prevent the spread of the virus. And finally, next slide before I open up for questions. We get a lot of questions about what sort of documentation is required. The Department of Labor just a couple nights ago issued some guidance on this. With respect to the paid sick leave benefit, they indicated that the IRS is going to specify through their forms and instructions and information what you need. They just published actually overnight some guidance on the IRS website, and I don't want to shoot from the hip, on that. I have looked it over. I can tell you it's going to be up on our website at our firm. If it's not already, will be within the next hour or so. But the IRS has issued some documentation guidelines there. What the Department of Labor has said so far is, at least with respect to the child care related leave, school closed, place of care closed, and so on, that you should hold on to documentation that shows the actual closure of the school. And it doesn't have to be anything formal. It can be something as simple as an email that was sent to parents, something posted on the school website or in a newspaper or online MLive type site or something like that. That would be fine. Same with respect to daycare sites. With that, I do want to leave some time for questions. So let me open it up. Do we have any questions related to these leave issues coming in?
We absolutely do. There's 36 here, 37. We'll try to get through them quickly. If we don't, I'll have you send them in, folks. The first one is, have you received any clarification from the Department of Labor or other governing authorities as to whether a shelter-in-place mandate qualifies an employee under point 1 in the new paid sick leave policy under FFCRA? I think you talked about that, but.
Yep, that's correct. That's an important question, so I'll reiterate. What the Department of Labor guidance indicates is that they do not consider a stay-at-home order like the one we have from Governor Whitmer here in Michigan or the similar orders in other states to be a qualifying reason under that section of the Paid Sick Leave Act. What they're suggesting is those employees should apply for unemployment benefits if their work site is closed, and that's not covered here.
Okay. Next one, discuss how 10 paid sick days on April 2nd work. We are under 50 employees. We are eligible. When do we release the payment under payroll?
Well, it depends. First of all, I mean, if you're under 50, you may qualify for the small business exemption. So you should take a look. And I think if, the discussion, obviously we covered a lot of things, but I think if the slides will be up later, you can see we've listed those there. But if it's going to affect the financial health of the business or your ability to operate in the ways that we discussed there, then you may be entitled to an exemption, and you should explore that based on your particular case. If not, the way it would work then is that you would pay those folks out through your normal payroll, just based on what they would normally work. So for example, let's say a full-time employee who normally works 40 hours per week, you would provide them with 40 hours of pay for week 1, 40 hours of pay for week 2, and then once they've hit that 80-hour mark, they've now exhausted that leave, and you'd have no further leave obligation.
Great. Next one is, are employees allowed to collect the emergency paid leave more than once during this period, or is this a one and done thing?
They're allowed to collect it up to the maximum for that type of leave. So for example, the paid sick leave, they're entitled to up to 80 hours. If they had a qualifying need more than once, it's theoretically possible. I don't think that's likely to happen. Obviously, for the folks who are out for a reason related to their own health, knowing what we know about these, 14-day incubation period and so forth, it's likely to be that they're going to be out of work for more than 14 days at least. So it seems highly unlikely. It's possible, at least, that for the child care related reasons, they might have, might take the leave at different times. For example, if they're sharing care obligations with a spouse or something like that. But the bottom line is it's a hard cap based on the number of hours for the paid sick leave. Once they use up 80, they're done. And if they've used that up and then they have another qualifying reason later, they can't take it again. So if they get sick, use up their 80, and then later their spouse is sick and they need to care for them, they don't get another 80.
Okay. We've heard this one quite a bit. How should we handle a situation where an employee who is at higher risk, 60 and over, is uncomfortable with coming to work? Is that employee covered under this act, or should they be taking paid time off?
That's a great question. And often it comes up in that context with elderly workers or older workers, or with folks who have, autoimmune diseases or things like that. Just, being concerned, being afraid, being cautious about contracting COVID-19 is not a category that's covered by the statute. At the same time, the Department of Labor guidance in answers to various different questions like this one and others is continuously emphasizing that they want to see employees and employers cooperate during, this difficult time to try to work together. So what we're seeing a lot of employers doing is just allowing these folks, although they're not entitled to paid sick leave, to use either other company provided leave. They could certainly use their normal vacation or PTO or things like that if they want to take some time off. And if that's allowed as paid time under your policy, you could allow them to do that, or just allowing unpaid leave. We're just letting people, I talked to 2 clients yesterday that had different particularized situations like this, and both of them decided they were just going to allow the employee to take unpaid leave. You may want to also inform the employee that they may be, I mean, we can't guarantee it as the employer, but they may be eligible, depending on the circumstances, for unemployment benefits. And so they can contact the UIA and determine that for themselves.
I have a similar question related to that. What if the employee has a letter from their doctor saying they have an immunodisorder and that they need to stay at home for a medical reason? Would that be a sick leave?
That, it depends a little bit how it's worded, but that may come within that second category of paid sick leave, that they're being advised to self-quarantine by a healthcare provider for reasons related to COVID-19. We don't have any specific guidance from the Department of Labor on that particular question yet, but I would say, you know, as you phrased it there, it seems to me from sort of a common sense point of view that that would fit within that category too.
Okay.
And again, all these things kind of turn on,
Yeah.
you know, sort of exactly what the situation is, but that would likely, I think, fall within that category too and entitle them to 2 weeks of paid sick leave. And then nothing more than that under this statute. They wouldn't be entitled to emergency FMLA for that reason. They may be entitled to regular FMLA if you have over 50 employees and that applies to you, which of course is unpaid leave. And then you may be able to process that as a serious health condition leave under normal FMLA if the medical documentation supports that.
Okay. Next one. This one's a little unique. Someone has an employee. They are rotating with their spouse to stay home every other week to care, to stay with their children. How would that be paid? Would that be the sick leave or the FLMA?
That could qualify as emergency FMLA, and if you agree with them that they can take the leave intermittently like that, then yes, they can take it that way. You can allow them to take it that way, and it would be covered by the emergency FMLA provisions.
Okay. Troy, I think I have a couple here for you. Let me go back to those. I can't find them. Well, the first one was, we ship orders. Can I go, if I'm not a critical company, can I go in and ship orders?
No. So, I mean, if you have not, if you're not critical infrastructure, those shipments are not critical infrastructure. And you haven't received a letter from any of your customers saying, you know, they are, the only way potentially that would be allowed is if you if it fell within the minimum basic operations exception. Sometimes we've seen that where one of the things is to maintain, you know, kind of inventory and stuff like that. And if something's going, you're going to lose inventory or something, you might be able to make an argument like that. But other than that, no.
No, okay, thank you. These are back to you, Dean. How do you formally become exempt if I'm under 50 employees? Do you need to submit an application? Is there someone you go to? How does that work?
Well, that's one of those things the Department of Labor hasn't clearly answered yet. What the guidance says is that an employer may claim this exemption if an authorized officer makes one of those 3 determinations that we talked about earlier. And so based on that language, it would suggest that, you know, the employer could make that determination if in fact they're able to make it in good faith and document it and not pay the benefit out. I say that though with the caveat that the Department of Labor may issue regulations or further guidance later that would say, for example, you have to apply to us first. Employers are in a difficult situation with this right now because there is no process for seeking that exemption or applying for it. And in fact, the DOL guidance that was published on this specifically said, don't send us anything right now. They're just not prepared to start dealing with this issue.
Okay.
What they have also said, though, I would add, is that there's a field guidance that's been issued to their enforcement officers that indicates that for the first 30 days, at least, of this FFCRA, from the date of passage through the first 30 days, which goes out to about mid-April, they're not going to impose any penalties on employers who fail to comply so long as they're acting in good faith. So if you continue to rely on what the DOL is publishing on their website, you act in good faith, and you can show you've done that by demonstrating, for example, that you or your HR professionals have attended webinars like this, that you've read available materials from the DOL and have done your best in good faith to comply. It may be determined later that you do have to pay the benefit, and you might have to come back and pay that, but they won't impose penalties or double damages or things like that that are normally in their sort of arsenal of enforcement tools. Again, that's only for the first 30 days, but that's another, I think, recognition of, you know, trying to help employers who they understand are struggling as we sort of try to fly this plane as they're building it.
Great, thank you. And just a couple here more to wrap up. I should have mentioned that the slides will be made available to you later today. We'll also get the slides and a recording of this up on site so you could go back through questions and answers. If we didn't get to your answers today, please send them to sbam@sbam.org and we'll get back to you. So just a couple more here before we go. I appreciate everyone's time. First one is, if you had laid off employees prior to April 1st, are they still eligible for paid sick leave?
If they're laid off and their job, their work site, their function isn't working right now, then they would not be eligible for this benefit. The Department of Labor guidelines indicate that they should apply for unemployment benefits under state law. And many of you probably heard there's been in the CARES Act some enhancements to an extra $600 added to that benefit for folks to try to help fill the gap for more people in terms of the gap between that unemployment benefit and their normal pay. And the state has also relaxed many of the normal rules. They don't have to be actively looking for work. They don't have to wait a week and all those sort of things. And the employer is not going to be charged for the COVID-related unemployment claims under these statutes.
Okay, great. And then the final one here is people that have laid off employees, how does that work for them? Do they need to bring them back before? Well, that's today. If they've laid off their employees, what applies to any of these employees? The FMLA, anything help the ones that are laid off already? Should they be called back?
Yeah, if they're already laid off, then they wouldn't be covered by either the paid sick leave benefit or the expanded FMLA. They can, while on layoff, seek unemployment benefits and receive those benefits, even if you're going to hire them back when conditions improve. But for now, they would be covered by the unemployment system.
Great. Well, thank you. So much to cover. Really good stuff here. I can't thank you enough, Troy and Dean, for your time. Warner Norcross Judd's been a great partner. We really appreciate it. Folks, if you didn't get your questions answered, send them again to sbam@sbam.org, and we will do our best to get those answers to you. But for now, we'll sign off, take a look at the couple other webinars we have this week, and don't forget the SBM Daily Update every day at 3 o'clock on Facebook Live and Zoom. All right, thanks everyone. Take care, crazy times, and as Rob and Brian would say, don't touch your face and wash your hands. Thank you.